pleadings and conversing. And you will get the instructions as well as the way how to draft these documents. Now, these are the things to which you will study, you will devote yourself, and before, suppose you are drafting a partnership deed, so you must study the Partnership Act. You are studying the sale deed, you must study the Transfer of Property Act, redemption deed, agreement to sell, dower deed. So these are legal documents, legal drafting, which an advocate is supposed to know from law of pleadings and conversing. Then comes the complicated, because for the sake of examination, law is very easy, but for the sake of practice, it is very difficult. Because you are called learned advocates, judges are called honorable judges. So they will maintain their honor, and you will maintain your learning, then the car will go. Because whether this is 2 wheels or 4 wheels, but they will keep their honor intact, and you will keep your learning intact. And once you keep your learning, automatically, the courage will come. And when you enter the court, you will feel that the judge is ignorant of law. I know, and today I will make him understand that I know everything, and I explain everything, and I instruct, and I give you. So, drafting according to law is your reflection of your personality. Now, these are a few things which I would like to bring to your notice, that it is not only the drafting, but your conduct also. If you poorly draft, then there will be an adverse effect on your personality. If you beautifully draft according to law, that will be a good impression on the judge hearing the case. So keep it and observe the law of drafting, which is very, very important. Now, sometimes difficulty arises that keeping from your drafting the witnesses which you produce. Because if you study and draft according to the law enunciated by the superior courts, then there is no need for further study. You will just read out your plaint, and that will be the reflection of your personality. So, when a witness is withheld, if a witness, somebody say that, look, this is a marginal witness, and he is not producing him, or the witness is not coming before the court, then the court will take adverse presumption against that person. On that kindly note, this is Supreme Court Monthly Review CMR 87, page 1667, and PLD 1990 Peshawar, page 100. Kindly short notes हो सर लिखे चेहरा, write the short notes that on what subject these two case lies. If a witness is withheld, or if a witness refuse to appear before the court in a witness box, then adverse presumption will be drawn against the party who is withholding it. Then sometime by mistake certain admissions are made in the pleadings, which is very painful for the judge, painful for the client. So do not make admissions. Try to be very sober, try to be very brief, without quoting the law, without making admissions before the court. Once you make an admission, then it is binding on you. And then your plaint, your written statement is not in accordance with law. It is not a legal drafting. It does not come within the definition of a legal draft. So try to be brief, without quoting the law, without resorting to admissions. But if there is an erroneous admission, erroneous means an admission by way of mistake, then that is not binding. The erroneous admission of a counsel is not binding on the client. On that, kindly note, it can be done and corrected through amendment. On this PLD 1963, Lahore, page 63, PLD 1963, Lahore, page 606. Then another. Second one is 1988 SCMR 322 and MLD 1995 page 290. Up any admission which is not compatible with the record of the case. For example, you say A is the son of B, you admit, but actually he is not the son of B. He is the son of the brother of B. So this is erroneous admission. You have made an erroneous admission, admission by mistake, and that too is not binding on the client. That is PLD 1976 Supreme Court, page 202. This case law is very important for you because while drafting, you will have to study it. How? Last one? Yes. This is a PLD 1976 Supreme Court, page 202. Now, another important aspect which was because of the admission of the learned counsel came to me in appeal, and that was that there were two brothers. They had property. One brother received a notice from the taxation department that this is your house. He went and recorded a statement that this is not my house, this is the house of my brother. So, when the counsel started drafting, he drafted, couched it in those words that this is not the house of my client, but this is the house of his brother, and he is liable to pay the taxes. Now, I personally conducted that case, a very dangerous admission, and on that the Supreme Court held, PLD 1975 Supreme Court 311, relevant at page 317. Supreme Court held that this erroneous admission by the maker and by the learned counsel, because out of fear, he said, out of fear of payment of tax, he said that this is not my house. Actually, he had purchased it through registered deed. There was an agreement to sell. It was followed by a registered deed. It was followed by the meter is his name, electric meter. Water connection is his name. He is in possession of the same. So, that was whether made by the learned counsel or by the party, that is an erroneous admission. So that fellow was granted the degree. Now, so many admissions are made, and admission is made, unfortunately, our clients are illiterate. They do not know the repercussions and the effects of law on their case. So the counsel, when they are instructed, I said once, I was doing a case, somebody said that this the counsel has made this. मैंने कहा counsel ने admission किया है लेकिन उसके instructions पर किया है, client ने instruct किया है, और client तो rustic है, belong to a far-flung area, do not know the consequences of law. That is why client come to us. So this is not the mistake of the counsel, but this is the mistake of the client who is wrongly instructed his counsel. So if you are wrongly instructed, if you are a competent man, काबिल आदमी हो, तब भी आप बेहतरीन ड्राफ्टिंग नहीं कर सकते क्योंकि आपको इंस्ट्रक्शंस गलत दी गए हैं. So try to take correct instructions from the client. And when the client correctly instruct you, then you will mold those instructions in your plan, in your written statement, in your evidence, in your list of witnesses, and you will get that case, you will get relief for your client. Then sometime Pardanashin lady who never come out, unfortunately rustic, domestic lady, Parda observing lady, do not know the consequences. So on that, any transaction with a Pardanashin lady, the burden lies on the person who derives benefit from that transaction. Burden does not lie on the Pardanashin lady. The person who is being benefited from the transaction, he will have to prove that she had the independent advice, she was warned, she was explained, the contents of the documents. So on that kindly write a few authorities. This is the PLD Duazarek Supreme Court, page 79, and MLD 90-334. So you will keep all these things in your mind, and then you will draft according to the observations of the learned judges in these judgments, and then you will become a very competent counsel. Sometime case comes and the question arises that entry in a death register. Some person die and he goes to the DHO, district health officer, and then enter the death date, time. But on the other hand, there is a mutation attested by Tahsildar and two witnesses and the person making the entry in Rozamcha Waqayati. So this will come before you while drafting, that which one will prevail, whether the entry in the death register will prevail or the entry in the mutation. Now kindly write on that NLR 1994, Civil Law, page 1990. 1990. Now, another question will come while legally drafting. That a matter enter is Roznamcha Waka, there is a Roznamcha with the Patwari, and any report when he received, he enter in that is called daily diary, Roznamcha Waqayati. And entry in the Roznamcha Waqayati and entry in the mutation, duly attested by the Tahsildar, testified by the two competent witnesses, admitted by the person making the admission. So which one will prevail? On that, the mutation will prevail and entry in the Roznamcha will not prevail. PLD 1988, Peshawar, page 48. 1988, Peshawar. 48, 48. So, these are the salient features, because if I would like to draft to you the partnership deed or so that will take time and you will not learn anything from it. Now, if you have got any question explanatory, now I am here, I am open to questioning and I will explain it, so that will become very easy. One thing I tell you that with due respect, with all due respect, any wrong drafting, any erroneous admission, that is forgivable. But intentional admission, that is not forgivable, because we have got a judgment of the Peshawar High Court. Kindly write it and study it. This is very important. This is a Musammat Hassan Zari versus Said Farosh advocate Dagar Bunair. Said Farosh was an advocate, and unfortunately in league with other, he made certain admissions which adversely was telling upon his credentials, and that case came before the Peshawar High Court. So kindly write it. Hassan Zari was a lady versus Said Farosh advocate Dagar Bunair, CLC 2000, page 433, 433. Do study it, so that you know the conduct of a person who calls himself as an advocate. If you open the Holy Quran, no more than 1,000 places, La ilaha illahu fattakhidhuhu wakeel, Rabbul Mashriq wal Maghribi, La ilaha illahu fattakhidhuhu wakeel. So this beautiful name, Wakeel, is the person to whom you place your complaint, you place your istighasa, you place your faryad. So that is Allah Almighty. But in this world, that beautiful name has been bestowed upon us. So if we are not honest to ourselves, let's be honest to Allah Almighty, because His beautiful name is on us. So when you study this Hassan Zari versus Said Farosh, so any person with a living conscience will start weeping that whether an advocate can do it, whether this is the conduct of the advocate. So do study it. This is very important, because there are so many judgments, but I have cited one for your guidance. Do study it. It is available in libraries. Now if you have got any question, I am here to answer. Some brothers have lately come. So if they have got any question, they can ask me.
Sir.
Okay, khair, all of you are Pashto speaking or Urdu speaking also? Pashto, the senior brother, junior brother,
जनाब एज पर लॉ चे दे प्लीडिंग्स के चमंग वेली दी चे यू हैव टू स्टेट द फैक्ट्स ओनली
not the law.
ठीक शो जनाब उस दल तमंग जर्नल ट्रेंड गोरू दो किस्म प्लीडिंग्स की जी जनाब यो हुई चे जर्नल प्लीडिंग्स उशी लका बीखी आए के आगे स्टांस खपल एक्सप्लेन कड़ी नवी ठीक शो यो वी आए के स्टांस हम एक्सप्लेन कड़ी वी सीनियरो हर सारियो शे एक्सप्लेन कड़ी वी इवन जजमेंट सम स्टेट कड़ी हुई दे दो रीजन थी जे कलम जर्नल प्लीडिंग्स को नो आए के कलेक्ट सपोज मो आर्गुमेंट्स के खपल प्लीज वाखलू एक्सप्लेन को जे आई हैव मूव दिस एप्लीकेशन या एनी सीएम चे मूव करे दे पदे दे ग्राउंड्स बांधे आर्गुमेंट्स के आगे मूव एजिटेट को जी ठीक शो जी आए के खबर अदाशी जे कला ऑर्डर शीट राशि या ऑर्डर जे पास शी आए के जज साहिबान चे दी नो अक्सर दासी हुई चे arguments heard and peruse the record जमूं स्टांस चे दे ऑर्डर शीट रा नशी जनाब आए कि यो दागा मसला दी ठीक शो उस ट्रेंड सरा वान दी दा सीनियर काउंसल्स हाई कोर्ट के सकई दी दा से कई जनाब चे कला दे सेकंड टाइप ऑफ ड्राफ्टिंग कई चे आए के स्टांस हम एक्सप्लेन वी आगे के लाम एक्सप्लेन वी आए के इवन जजमेंट हम कोर्ट कड़ी प्लीडिंग्स के जनाब
Court सके don't speak of quoting. When I draft in the High Court a revision, that we do it in the Supreme Court and in the High Court. Because I study a judgment, you say that I had argued this point, I produced this case law, I produced that, but the learned judge has not written anything. Arguments heard and record perused and then facts and then either rejected or accepted.
Exactly.
So, an appeal, that is not the pleading. That is your memorandum of appeal under Order 41 of the Civil Procedure Code. Pleading are under Section Order 5, Rule 6. But in appeal, you can quote the law. When I draft, I quote the law and I annex the judgments also. Judgment at page flana, judgment at page flana, judgment at page flana. Because when I argue, the learned judge say, where is that judgment? Sir, that is at page 190. Kindly see. That is the Supreme Court judgment. That is the high. But that is not pleading. Pleading is in the trial court. That is under Order 5 and Order 6 of the Civil Procedure Code. Appeal is under Order 45, 41 Rule 1 of the Civil Procedure Code. In appeal, you can quote, you can explain, rather you can annex law, case law, getting a copy, photostat copy of the book and annex it. And if the judge say, where is that? You can say, sir, that is at page 190.
जनाब दा खुदा सो एक्सप्लेन करल जनाब खुदे की इशू दा गवी चिकता सो खपल स्टांस ऑन द रिकॉर्ड रोडला कना जी नो दे की प्रो एंड कॉन्ट्रा जजमेंट सी ओपोनेंट काउंसिल चे दे नो आगे रिबटल के चूंकि यू आर वेल अवेयर ऑफ दैट कि हर जज खपल ओपिनियन में इशू बांधे जी